Karen Reed just keeps on winning, folks. You must follow the law. The law says...
Glorious. Is it a lawsuit? Probably. Why not?
Well, hello, everybody, and welcome back to Buckle Up, It's the Law with attorney Larry Forman. Folks, Karen Reed just keeps on winning, folks. I am so excited to share this update with you all. Once again, the judge has finally ruled on the defense's motion to dismiss, and boy, oh boy, it is chef's kiss. It is chef's kiss. Basically, if you remember, Damon Seligson, whom I interviewed on this channel, and we've covered the most recent hearing at the end of September. I believe it was on September 22nd, 2025. And just this past Friday, October 3rd, 2025, the judge finally ruled on the defense's motion to dismiss, granting it in relevant part. Now, what does that mean? Remember that there are a multitude of claims in the Karen Reed's civil trial that the O'Keefe family are suing her for, namely wrongful death and consortium claims related to the wrongful death, loss of enjoyment of life, negligent, intentional, reckless infliction of emotional distress. The negligent infliction of emotional distress claim asserted by Kaylee O'Keefe is officially dismissed as of today. Goodbye, claim, and that is only the beginning, folks. So how did the judge arrive at his ruling? The judge writes as follows. The defendants argue that none of the plaintiffs have actionable claims for negligent infliction of emotional distress because their alleged distress did not occur contemporaneously with John's death. If you remember, the whole issue that Damon Seligson argued on behalf of Karen back in court and in their motion was that the death occurred over here and their knowledge arrived over here, and there is no concurrent event. They didn't, see the car strike, or, Higgins's fist strike John's face, causing him to be killed. And there's case law on it, which we're not going to read so that you guys don't get bored. But the judge goes on. A family member is entitled to emotional distress when they either witness the decedent's actual injury or come upon the injured promptly after the injury. Now, the O'Keefes allege that Reed discovered John buried in the snow at approximately 6:03 a.m. You all remember that from the criminal trial. And he was subsequently pronounced deceased at the hospital at 7:50 a.m. that day. Now, Margaret, John, and Paul, mom, dad, and brother, each state that they learned of John's admission to the hospital shortly thereafter. But Kaylee's negligent infliction of emotional distress claim stands on different footing. The judge says that Kaylee alleges she learned of John's death or injury when defendant Reed awoke her at approximately 4:30 a.m. on January 29th, 2022. She also alleges that she heard Reed say, John never came home, maybe I did something, maybe a snowplow hit him, maybe I'd hit him, maybe I hit him, we were in an argument, maybe he got hit by a snowplow. So Kaylee states as a result of Kaylee's conversation with Karen Reed, in her presence, she, quote, perceived the injuries caused to her guardian, Uncle John, and perceived the injury-producing event. But if you take those things together, the judge goes on, the complaint does not allege that Kaylee learned of John's death or injury at 4:30, but instead learned that he may be injured at the time, not that he may be deceased. That's the key. Mom, dad, and brother learned that he was deceased at the hospital at 7:50. Kaylee only suspected that he may be injured. There was no inkling to Kaylee to believe that John may be gone. And as a result of that, the judge dismissed officially the claim against Karen Reed for negligent infliction of emotional distress on behalf of Kaylee O'Keefe and Kaylee O'Keefe alone. Now, that may seem like, well, Larry, You just hype this all up? Are you just trying to get video clicks or something? Like, why would you say all these awesome things and now we learn that only one claim has been officially dismissed and everything else still stays? Folks, this is how it starts. When you are in a civil case, very seldom, very rarely do you file a motion that just gets automatically granted and you walk away with a W, victorious and happy and slap happy and ready to rock and roll. Unfortunately, life doesn't work that way. In civil cases, it is a long, drawn out, and often treacherous process. And that is the way things are. If you may recall, the judge even indicated in the previous hearing that he is happy to give the litigants a trial date of spring 2026. Now, based on the fact that we are about to have 10 more cross-claim defendants entering the scene, namely the Alberts and the McCabe's and Higgy, there is absolutely no way that this is going to be in any way, shape, or form resolved by spring of next year, maybe spring of the following year. We can probably get a 2027 trial date, and that's probably what we're looking at. So you see, folks, we are probably at least 18 months away from jury trial, and this is what's known as death by 1,000 paper cuts. Death by 1,000 razors. Call it what you will. There is very rarely, I shouldn't say never, I was about to say never, very rarely do you have a situation where you just nuke the complaint and the whole thing gets destroyed. Sometimes it happens. I mean, I have seen it. I have done it. I have also done it this way. It's a normal practice. Absolutely normal practice for for lawyers, I should say, to file these motions. And there are going to be more. There are going to be more motions as more evidence comes to light, as more information comes to light, especially when they start the depositions, folks. When they start deposing Jennifer McCabe and Matthew McCabe and Brian Albert and all the rest of the Alberts and Higgins, when they all start giving depositions, it's no longer the prosecutor and Alan Jackson fighting for their lives. You know, prosecutor trying to get a conviction and Alan Jackson trying to acquit Karen. No, folks. This time, the questions are going to be different. They're going to be more fierce. They're going to be more probing. They're going to be far more invasive. And they better buckle up because justice is coming. Have you or someone you love been injured as a result of someone else's negligence? Or worse, you lost a loved one because of it? I am attorney Larry Forman, and myself and my team of trial lawyers are ready to fight for you and get you the maximum compensation allowable under the law. We know the system. We know how to win anywhere in the United States, 24 hours a day. Call 1-844-77-4-HURT. That's 1-844-77-4-HURT. And let's get you every dollar you deserve. Dial that number and buckle up. Let's win this ride. They thought that they skated away from this. Little did they know, they literally walked into the lion's den. They walked in to the den of Karen Reed, who is going, with the help of her lawyers, to devour all the people responsible for the death of John O'Keefe. And you will see there will be additional motions as we will see them trickling in. Maybe we'll see some this year. More than likely, we will see more of them next year. I have my source inside the team, and hopefully I will be able to get information to you as it comes in and as it's going to be hot for there's going to be very, very long periods of cold, so be prepared for that. These things do not move fast, like I said. These 18 months are going to be long, but they're going to be worth it, folks. So I hope you all enjoyed it. I hope you all learned something. I'm telling you, there are going to be more dismissals. There are going to be more motions, and we're going to see, imagine it's like an ice cube, and you are the sculptor, as Karen, if you will. And you're slowly chopping away at this ice cube, and these pieces are falling off. And you're like, but it's just an ice cube. There's nothing there. But before you know it, you have a beautiful, gorgeous sculpture that you simply cannot take your eyes off. And that is what Karen Reed's team is building. Little tiny pieces being chopped off, little tiny pieces being chipped away. Here, we lost Kaylee's claim. Okay, so the other claims get granted and they stay. So what? It is not the end. This is a huge, huge, I cannot emphasize this enough, victory for Karen Reed. And I will see you all in the next video, folks. Bye, everybody.